This is William and Lonsdale, a podcast about the legal ecosystem and the fascinating people who make it tick. Today, your host Michael Green speaks with Lizzie O'Shea, principal lawyer at Maurice Blackburn, advocate and author. Lizzie is an internationally renowned expert on digital privacy rights and the intersection between technology, privacy and the law. She has worked and studied internationally, including getting a master's from Columbia University, and now specialises in class actions, recently leading the class action against tech giant Uber. One of the cases Lizzie is most proud of, though, is actually one she lost. She acted on behalf of an abortion clinic in East Melbourne, bringing a claim against Melbourne City Council on behalf of the employees, who received constant harassment going to and from their workplace every day. Despite losing the case, it remains a highlight for Lizzie because it did what she believes the law can do. It laid the foundation for genuine change.
And we were ultimately unsuccessful, so it was I definitely was a big loser on that case. But the very important thing about that was it created the terrain for law reform. So what the clinic was then able to do was to go to elected members of parliament and say, we've tried everything to fix this problem. What we really need is legislative reform to create a bubble zone. This is your job now. And the fact of the failure of the Supreme Court action was the foundation for that claim. And to their credit, MPs responded and introduced a protection zone around the clinic shortly thereafter. So protection zones around health services that provide abortions. You know, the day that was introduced, it stopped, and they haven't had harassment since.
Our guest this morning on Lives in Law is Lizzie O'Shea, who is a principal with Maurice Blackburn. Good morning, Lizzie.
Good morning. Thanks for having me.
It's our pleasure, Lizzie. So, Lizzie, you're a principal at Maurice Blackburn, and on my calculations, you've been in practice about 17 years?
It's quite a confronting number, but yes, I think that's good calculations.
So what's your role at Maurice Blackburn? What do you do? I mean, they're a big firm, a dynamic firm. Where do you fit in?
I have been there a long time. I do remember when I started it was a lot smaller, and I've worked in many different departments, but at the moment I'm a principal in the class actions department. So I run class actions generally for corporate misconduct, bringing claims on behalf of lots of different people. And in general, my practice has tended to focus on technology companies, incidentally, which crosses over with some of my other interests.
Well, explain the mechanics of class actions to us. I come from a generation where litigation was one client who walked into your office, sat down, told you a story, and you said, well, you've got a good cause of action or you haven't, and you went from there based on your client's instructions. But I guess if you've got thousands of clients in the class, it's very different. So how does a class action commence? I mean, who creates the action? Who comes to you and says, I think I've got a cause of action or I want to sue somebody? And then how does it run from there?
Yeah, it's an interesting question because I think the way that class actions work they're often quite different to how people expect or how law is traditionally practiced. Usually it's a passive exercise where you get a referral from a client, they give you instructions and you may have to issue proceedings and you work with them through the process of bringing their case. This is obviously quite different, and usually the way that it comes about is that we identify some form of wrongdoing or suspected wrongdoing, and that might be reported in the media. It may be brought to us by a particular body or civil society organisation or peak body, and then we have to do a lot of investigative work before we commence a proceeding to work out if it's viable. And that can be a big part of the case, figuring out whether you've got a decent cause of action based on limited publicly available material, figuring out how much might have been lost, how many people might be affected. And then, of course, that impacts how the case is run as well. You have a duty to one representative or lead claimant, of course, and that's the formal structure of the litigation, but you are potentially bringing this claim on behalf of tens of thousands, hundreds of thousands of people, which is its own particular issue when it comes to management of the matter. You have to make sure that you understand what they may have lost. You have to communicate with them. You have to make sure that what you're doing reflects the interests of the entire group, which brings in lots of different ethical considerations, practical considerations. I mean, in general, the field of law, I really enjoy it because you do have to put a huge amount of effort into every step of the litigation. You have to chase down every possible lead. You have to examine every possible issue from all angles, and you have the time to do that. I mean, that can mean that these cases take a long time, but in part that's because they're dealing with very serious issues, very large amounts of loss, very significant liability concerns. So that's justified in my opinion, and I think a lot of class members would agree with that. But it can mean that they take a long time, but I think they're done thoroughly and well, and they're hard fought. And so for all those reasons, I enjoy that field of practice. It's certainly not like my colleagues in the asbestos department who might have someone present with asbestosis, have to issue proceedings within a week, have to get a decision within 3 months. These are matters that are quite different. They can take many years, but they are very hotly contested. They're obviously of significant interest to the public and the many people who are affected. And that's what I really enjoy about it. But the length of time does require significant stamina as well.
Can you issue in any court? Do all courts have jurisdiction to hear a class action, or is it specifically Supreme Court or Federal Court?
Both the Supreme Court and the Federal Court have regimes or lists that are specific for dealing with this and have experienced judicial officers that can manage class actions. I mean, it's just like any other claim. So if you've got jurisdiction to issue in a particular court, you can do that on behalf of the group. So there's procedural mechanisms to permit that in both the state and federal regimes. Sometimes you may not have a federal cause of action, which limits that. And, of course, you may elect to issue in the federal court as well. But both, I think, are very competent jurisdictions for managing class actions. The other distinction, of course, is that the Victorian Supreme Court or the Victorian regime now permits contingency fees, which is a recent change, which does mean that many plaintiff lawyers treat the two prospects differently and may consider how to bring a claim, and in the course of that consideration may work out whether they want to do it on a contingency fee basis.
Why don't you tell us what a contingency fee is, please, Lizzie, for those uneducated or those like me who may have forgotten?
Of course. So obviously how lawyers charge costs is always a contentious matter. It's always a matter that's close to any lawyer's heart. And in general, as I'm sure many of your listeners will know, that's usually done on an hourly basis, based on scale and the like, and you charge your client as to how much time and the kinds of tasks that you do. Contingency fees are obviously different because instead of that process of documenting the work that you've done, you instead take a percentage of the total recovery. And I think in many ways that's an efficient way to run class actions in particular. So it's not available in relation to other kinds of claims, but it is in relation to class actions because it does align the lawyer's interests with the client's. And it encourages efficiency as well. It's a relatively recent phenomenon, so it's the last couple of years, but it is, I think it's fair to say, working well so far. And there's a lot of scrutiny from judges. Obviously, that's the other protection in class actions. If I don't talk to many thousands of clients, they might rightfully feel concerned that their interests aren't being represented in the course of the litigation through the lead plaintiff. But the mechanism there to protect them is that courts supervise these matters very closely. That is probably a significant distinction as compared to other forms of litigation. You are constantly aware, I think, as a class actions litigator, that you will be scrutinised by the court and that the court has a very active role in managing your matter. And if they didn't do that, I think it's very easy for these kinds of proceedings to get bogged down. And that's also true on costs. So that's true in relation to non-contingency fee matters. But when you are charging a percentage, that there's processes for approval for that that mean that the judge has a say and an interest and a protective role for the remainder of the group. And that I think is very important, and it makes the system trustworthy.
Just a couple more questions, just to clarify it for me, or I'm just interested to know. So in a big class action, you've got thousands of clients, maybe shareholders in a company or something like that. How big a team do you assemble within the firm, roughly?
It can be very large. There's always a principal obviously supervising it, but at any time they can have 2 or 3 lawyers working for them, 10, 20 paralegals. If you talk about some of these very large consumer class actions for things like add-on insurance or consumer products that have gone wrong or cash converters overcharging interest rates on loans, you may have to deal with hundreds of thousands of clients, which requires many paralegals and client service officers to be able to speak to them, because a lot of them may have questions and concerns and they want things clarified. So that can be a very large team. And it's important because these are the people who are affected. They want to know how this litigation works. They may have suffered considerably if we're talking about a product defect, a medical product that might have resulted in them having a life of pain or multiple surgeries. It's very legitimate, I think, that they be able to speak to someone and find out how this matter is progressing. So that can be a very large component of the team, people who are there to speak to clients. And then, of course, we have to balloon up and down according to whether we're in trial, whether in some stage of the proceeding that doesn't require a huge amount of resourcing. And partly that's because I think we are very intent on running these matters efficiently, because we are aware that money that we spend on this litigation may in fact be coming out of the pockets eventually of people who have suffered wrong. Because if we can't run this efficiently and we have to charge them costs, that is difficult. I mean, part of the way in which this regime works well is that no client has to pay anything up front in order to be part of the class, and that's the appropriate way to run it. But we also want to make sure that we run these matters efficiently so that we can get good settlements as quickly as possible, or decisions in favour of our clients as quickly as possible. And we want to be able to make sure that that money goes to the people who need it.
Do you normally have an insurer on the other side, or is that a sometimes thing?
That's much more a sometimes thing. It can sometimes be an insurer. That's obviously important to know because if there's no prospect of recovery because the company or the entity might in fact not be able to pay any compensation, that's a problem. So it's a mix. Sometimes they're extremely profitable companies, of course, that have plenty of resources at their disposal to pay out any compensation owing.
Lizzie, you mentioned that your team balloons in and out depending on, I guess, the stage of the litigation. Does this mean that there are people within the firm who at some stage are doing nothing, then you take them up? Or do you bring in people and then let people go?
It is a challenge managing a large group of lawyers where the work that comes in might be lumpy. There may be periods of intense work required and then quiet times as we go through different stages of the litigation. So full credit to our practice manager. She has a very difficult job, but she does it very, very well. So that's when it comes to lawyers, who are obviously people who are expensive by the hour and have to be managed efficiently. More generally, if you have 100,000 people in your class and they're calling up wanting to find out because maybe the matter's just settled, they want to find out what's happened. We do have to recruit large numbers of people, usually law students or people in the early stages of their career, to respond to those calls. It's a good form of experience for people who've never worked in the law before, but we obviously brief them very carefully so they know what kinds of questions are likely to come up and they know how to answer them. And obviously when curly ones come forward, we have lawyers at their disposal to answer them. So at various times, we may be having a situation where we've got tens, dozens of paralegals working for us, and other times none. There can be periods where those people go on to work in other departments in the firm. Part of the benefit of being in a firm of our size is that we've got lots of different departments who have lots of different needs. So, there's a paralegal who's worked for us for a while, but their contract comes to an end. They may well end up working in another part of the firm because they like working there. So it's interesting because you can see the same faces working in different departments. It makes for a nicer communal environment, in my opinion, but it also means that the experience that those people have gotten translates across to other departments as well.
For the law students who listen to our podcasts, what site do they go to find out if there's a job offering at Blackburn's for a class action, being a paralegal on a class action? How do they find out?
So those jobs are advertised on our website, and obviously if they're interested in working at the firm, the other way to find out more about Blackburn's is to talk to a lawyer who works there or talk to someone like me, find out whether it might suit them, and then that person can also help them keep an eye out for opportunities as they arise. I mean, it's obviously a very dynamic department that can grow and shrink according to the needs of a particular class action or a particular period in the year, which might be extra busy because there's multiple trials going on. So it can move very quickly. So I'd encourage anyone who's interested in the firm's work to get in touch with lawyers. In my experience, they're all very friendly and open and interested and like to talk to people who are interested in the work we do. And that can be a good way to find out about opportunities.
So moving on, still talking about class actions, What role do litigation funders play in class actions? Are they an integral part of it?
Yeah, so litigation funding is an option that's available to lead plaintiffs if they're concerned about potential liability. So litigation funders can fund adverse cost liability. So in the event that a class action is unsuccessful or the plaintiff loses, it's the lead plaintiff, not anyone else in the class, who is liable for the costs of the other side in the system that we have. And that's a big risk, and understandably lead plaintiffs might feel concerned about that. You can obtain insurance products to protect you against that. So to say that for a fee that might not be paid up front but is essentially part of the package of the litigation, the lead plaintiff is protected from that adverse cost risk for the course of the litigation. The other thing that litigation funders sometimes do is pay either some or all of the costs along the way that facilitate the class action proceeding. And I mean, more generally as well, litigation funding is available in other kinds of cases as well. There may be a scenario where a plaintiff generally wants to bring a case but doesn't have the funds to be able to bring it, but they have a good claim, and a funder might work with them to be able to provide that access to justice to allow them to bring the claim and then take a portion of the proceeds of any recovery in the event that the case is successful. I mean, they also wear the risk. So if the case is not successful, they don't recover their fees. I think litigation funding is an important part of the ecosystem of providing access to justice. A lot of people, I think, are concerned about the role they play, but there are very strict rules. In my entire life of practice as well, I've observed how people work with funders, and there are strict rules about how much they can be involved in strategic decision-making on the part of the lawyers who are running the matter. And in my experience, they're very respectful of that distinction, and they understand that in a class...
Can I just clarify there? What you're saying is funders don't put pressure on the lawyers to make a decision which the funders would like them to make.
That's correct. And in general, in a class action, you take your instructions as a lawyer from the lead plaintiff and you work with them so they're in a position to give you meaningful instructions, because these are complex matters that require a huge amount of thinking and understanding of risk to be able to make a decision. But it's not a situation where the litigation funder is putting pressure on the lead plaintiff or the lawyers for a particular outcome. And so it's a very professional relationship, and I've always found it to be very ethical. That's certainly my personal experience of working in this space. And I think it does provide people who would otherwise not be able to bring claims with access to justice. There are other mechanisms for that as well. I mean, you know, Maurice Blackburn generally runs many matters on a no-win, no-fee basis for people who've been injured at work or on the roads. That's a similar dynamic in the sense that we won't charge anybody unless we're successful, and then the costs come out of the proceeds of that claim. And that is another facilitation of access to justice, which I think is incredibly important. I don't think this legal system would work if it wasn't for those kinds of mechanisms in place. There's a role for them within the environment, and I think there has to be a mix. You know, I wouldn't say that companies like Maurice Blackburn or firms like Maurice Blackburn have to provide a substitute version of legal aid, for example. I think there's a role for legal aid. There's a role for no-win, no-fee arrangements like we run in injuries matters. I think there's also a role for litigation funding. And I think there's also a role for law firms engaging in self-funding too, as in essentially running either class actions, no-win, no-fee, or at times using contingency fee arrangements to self-fund litigation.
With the no-win, no-fee matters, firms obviously make a decision that they think it's going to win. That's why they're going to take it on.
Yeah.
Are litigation funders the same? Do they carefully assess a matter, a cause of action, and will only fund it if they think it's got a reasonable chance of success?
Yeah, absolutely. I mean, I think they would consider it unethical to fund things that, or it would be difficult to justify ethically funding things that they didn't have in comfort that there was a reasonable chance of success. I mean, you can't ethically bring claims that you don't think have merit. And so, you know, they obviously work with lawyers to figure out what kind of risk they would be taking on, and they may tailor the arrangement to reflect that risk so that after certain periods maybe they stop funding, or there's a budget and that's the ceiling. And so there's all sorts of a variety of arrangements that exist. But in every instance, understandably, the funder wants to know the kind of risk they face. Often they want the law firm to have some skin in the game as well, you know, that they don't pay all their fees up front, so that creates an efficiency with the lawyers as well. And they're upfront, of course, with the client about the product they're offering or the service they're offering, so that they can make an informed decision too.
But your overriding point is you don't think the system can survive or can run for the benefit of plaintiffs and the benefit of users of the system without litigation funders, class actions, matters of these sorts of arrangements?
I think they provide a pretty important service in the ecosystem for delivering access to justice. A lot of the complaints I hear about litigation funding or even contingency fees, in my opinion, are sometimes forgetful of the fact that there's an expectation that law firms like Blackburn's will run a matter for 3, 4, 5 years without being paid and expect to wear that risk as a service of sorts to the client, but obviously to the system in general, that these kinds of claims need to be brought because it's about respect for the rule of law, it's about justice being seen to be done, because there may be a very serious wrongdoing. I think that it is very easy to forget that those claims just have to be brought somehow without people being paid until the outcome is positive, and that there's a real risk as well that they may fail. And in those circumstances, I think there's a role to play for all these kinds of methods for facilitating access to justice that sometimes are easily forgotten. I do think funding arrangements and even conditional fee arrangements among people who've experienced injuries and the like have delivered a huge amount of access to justice to people who would otherwise never be able to subsidise their own litigation, would never see justice, might have experienced significant harm, significant injuries, lifelong changes that have had a lifelong impact upon them. And they deserve access to justice, and we don't have a system that facilitates legal aid for all of those people. And I think that the private sector has come in and offers some interesting and important mechanisms for delivering that service, and there's a role for it to play.
William and Lonsdale is brought to you by Green's List, one of the leading multidisciplinary barristers lists in Australia. Green's List believe in promoting conversation around the ideas and issues that shape not only our legal system, but our wider community.
Lizzie, we better get back to the start of your journey, but it's interesting to hear where you're at and where Blackburns are at. It's very, very interesting. So you come from a family of lawyers.
Oh, God, guilty as charged.
Well, you better tell us who those lawyers were and are, and was that why you went into the law?
That is a funny question, actually, because I think the first answer is no, to be honest. I saw a lot of lawyers and I wasn't sure I wanted to do it, but I was completely ambivalent about doing a law degree, but I do really enjoy practice. So for any law students listening who don't enjoy doing their law degree, rest assured, you may have a much happier life in practice than you had as a student. That's the first thing I'd say. So it's true. My maternal grandfather was a lawyer. My mother was a lawyer. She became a lawyer first, straight out of school. And my father was a maths teacher and then subsequently became a lawyer. One of my sisters has since become a lawyer, although she doesn't practice. So there's a lot of fighting at our dinner table. It's all very procedural and respectful, but certainly it's a family of advocates. And I've always enjoyed that. It's certainly a place at my kitchen table growing up was certainly a place where you could put forward your arguments and expect to be heard. We had a kids union and that used to organise against the parental oligarchy. And
I hope the oligarchy won.
Unfortunately, no. But we had a very respectful but argumentative childhood, and I enjoyed that. I didn't really ever consider that I would become a lawyer, to be honest, but it seemed like a useful degree to obtain. It certainly served both my parents well, and I can see the utility of trying to use words to change the world, trying to have an impact on society by making considered arguments. I think it's not the only way to change the world, but it is a very important one. And of course, the other big issue for me was being able to speak for people who wouldn't otherwise be listened to, and to do that in a respectful manner, and to take very important questions up to the highest levels of power and be there on behalf of people who would otherwise be ignored. That struck me as a very important role that lawyers play, and I wanted to be part of that.
Were you thinking like this when you were a law student? I mean, that early in your career, were you having those thoughts about social justice, speaking on behalf of those who can't be heard, etc.?
I think I was thinking about that from primary school. I think I've always thought about that. Certainly that sense of justice was something that from a very young age was refined in me or encouraged. I was certainly encouraged to think about what it means to live in a just society, what it means to be fair, and how to navigate those kinds of complex questions. How power is distributed in society and what you might be able to do about it. That's something that I feel like as a child I was thinking about, not in an indoctrination sense, but, how you think about the world can be framed by those kinds of ideas, and that's certainly how I was raised. So in that sense, when I was doing my law degree, there was never an expectation, I suppose, that I would just be interested in excellence or perfection in the law as a theoretical exercise. It was very much law as practice rather than an idea.
You said you didn't enjoy university or didn't enjoy studying law.
It's true.
Did you enjoy the university experience beyond the studying of law?
I had a very good time, in part because I was involved in a lot of student activism. I think that's an important thing to do. I saw the opportunity to explore those kinds of activities and ideas and figure out what I thought in the world was going wrong and what I could do about it. So I felt like it was a real opportunity to do that kind of work, which was important, and to learn about how to make yourself heard within various environments, in the classroom, in campus activities, in campus government, all that kind of stuff. So that was enjoyable. I mean, it wasn't that it was a terrible law degree experience, but I certainly, it wasn't necessarily what I expected. I found it very intellectually challenging, which I think is both a good and bad thing. It's engaging, but it's obviously very hard work. And I also kind of yearned for that real practical expression of the law rather than just its theoretical underpinnings. I do actually consider myself a very theoretical person. Like, I like thinking about ideas, but to me, they really gain meaning and valence when they're put into practice. And what you do is really important, not just what you say. And so I was itching to sort of get out into the world and put some of these ideas into practice. And a law degree takes a long time. So I'm probably at heart a very impatient person.
So you get out into the world in about 2007 by doing your articles at Maurice Blackburn. How did that come about? I mean, how did you get your articles there? And it was articles, was it? The old-fashioned articles?
It was old-fashioned articles. That's right, I'm old-fashioned, yeah.
And did you enjoy that experience? I mean, Maurice Blackburn always been a dynamic firm, always looking ahead, looking to the future, looking to address issues and in creative ways. What was it like being an article clerk in that environment?
Yeah, it's very interesting because I think when you're at university, and maybe this is partly what turned me off my law degree, there's this expectation that you'll go to top-tier firms and that's the picture of success. At least when I was at Melbourne University, that was the message that was drummed into you. If you're not offered a role at one of these top-tier firms, then you're really a second-class citizen. And what I found when I went to Maurice Blackburn was I really felt at home. I felt like I'd found a place where I could feel comfortable and happy to practice, and I feel good about what I do. And sometimes I think plaintiff lawyers are almost treated like a class different to the rest of lawyers. We do work that's quite different. We're always on the side of a certain group of people, not the usual kind of business of law. And often we're not even considered when it comes to career opportunities. Certainly when I was at university, it wasn't put forward as one. When I got there, I realised, there's this field of practice you can do, which is right up my alley. You know, you look at problems that everyday people face and you're there to solve them for them. And, you know, part of it is that I know the tradition and the history of the firm. It's over 100 years old, founded by Maurice Blackburn himself, a member of parliament, Labor member of parliament. He and his wife Doris, charmingly, Maurice and Doris, were in fact, you know, some of the founding members of the first Aboriginal Advancement League, so interested in Aboriginal rights, all these kinds of things. Long history of activism, of practicing law for people who aren't repeat players in the courtroom. And that struck me as a place that I wanted to practice in. So I did my interview with Bernard Murphy, who is the managing partner, the chair of the firm at the time, who's now a federal court judge. And I think he saw something in me because he just knew that he wanted me to work there. And he's a charismatic guy. He's also very persistent. So he got on the phone. He's like, "You got to come work for us." They like to remind me that I was in the top 2 picks of the article clerks that year, so obviously not number one, which is fine. But I think they saw that I was the right fit culturally and had the right kind of attitude for plaintiff law, and they were right. It was the right call for me, and I was, you know, the fact that I've been there on and off for a very long time, I think is testament to that. And it was a group of people who practice law in a particular way that I felt at home with, that I felt aligned with, and I felt it was a place that was where I wanted to be, that were doing interesting things, that weren't constricted by traditional methods of practicing law, that looked for new ways to create access to justice, and it was a tradition that I wanted to be part of.
Within the firm in those early days, you were a union delegate? I was
involved in the union almost as soon as I wrote.
Which union?
The Australian Services Union, yep.
And what role did a union play within the Maurice Blackburn workplace?
I think it plays an absolutely vital role.
When you say play, still does?
Still does, yeah, absolutely. So we have an enterprise bargaining agreement at Maurice Blackburn that has very good conditions, in my opinion, but that have been negotiated over time. I mean, I've spoke to our delegate this morning. This is an institution that is a big part of firm life. And in my opinion, part of what has made my experience at Maurice Blackburn so good is that it is a union firm. It actually does follow through on its promise.
We should say for people who don't know, historically, Maurice Blackburn has acted on behalf of many unions, many of the large unions.
Yeah, that's
right. And
I
assume still does.
Yeah, correct. So we do industrial work. We obviously work for members as well who might have experienced injuries and get referred to us to do that work or similar. I mean, yeah, absolutely. Industrial work is a big part of what the firm does. And so we represent a large number of unions when they get into disputes and have various issues they want resolved. So industrial employment work as well as injuries work. But yeah, it's an example, I think, of the organisation following through on that promise. So it does this work, but it also does deliver for people who work within the firm and makes good on that promise. It understands the value of unionism. So part of the reason why I think it's so important is there's a place to raise your disputes. They can be, or concerns about how you work, and there's a collective method for having that heard to management. So I've been involved in the union from the get-go as a delegate, involved in negotiating enterprise bargaining agreements, including as a senior lawyer with management. And so that would often be a lengthy process where we determine what kind of conditions and terms are included in that agreement. And, that affects all the staff. And so you have to take a lot of calls from different people within the firm. You obviously have to negotiate with people who then supervise you later, perhaps, all of which can be very stressful at times. It's obviously very interesting, but it fundamentally, in my opinion, contributes to a functional and enjoyable workplace. The culture of the firm, I think, is very, very good. Many people have high satisfaction rates with the work they do at the firm. In part, that's because I think they know that the work they do is for people who've experienced often harm and they take pride in that work. But it's also because we have a respectful workplace. We do deliver on that promise. We make sure that there are problems in the workplace, they get resolved in a formal fashion, in a negotiated manner, in a respectful way. And that contributes to a dynamic of respect within the workplace that I think is fundamentally very important. And to me, that's a primary reason why I've stayed in the firm so long. It's not always directly the result of the union, but I think so many flow-on effects that are really positive about the workplace that we have can be traced back to that union representation and that sense that when people want to be heard within the firm, there's a mechanism for doing that, and management will listen. I don't think it's always easy for management. They've often got difficult stakeholders to please.
Well, for someone like you, you're now part of management.
I am. So I manage lawyers. I mean, I don't own the firm, but I do absolutely manage lawyers. So in part, I'm grateful for the EBA, for example, existing, the Enterprise Bargaining Agreement existing, because it gives me a format for figuring out how to manage staff well. And it gives me a reference point to say, well, this is what we agreed in the EBA, and that's what, the union had determined was in the interests of people who work here. So I think it's good for everybody. It allows issues that are a problem with management to be brought to the attention of the firm, and it creates, kind of efficiencies in management as well. And you get a huge amount of buy-in from employees, which I think is very, very valuable. So for me, that's a big part of it. I'm not saying that it's a perfect institution. No institution is by any means. And, there's always things we can do to improve. But reflecting on many years there, that's what I would put down a significant portion of the high-quality culture of a respectful workplace, in a sense that we're in together in a shared project, and that we have something to be proud of in that respect.
Lizzie, after doing your articles, you immediately travel overseas and spend, I think, more than a year overseas, maybe 2 years, some time in Ireland, some time in Geneva with the International Labour Organisation, and sometimes in New Orleans with Reprieve. Why did you travel? Why so soon after your articles did you travel?
Well, I got the opportunity with Maurice Blackburn to travel abroad. They were looking for someone to set up an office in Ireland to do litigation funding there in Europe. And so it's an opportunity I couldn't turn down, I don't think. I mean, I love travelling. I love meeting people from different parts of the world. Sometimes Australia can feel a bit confined or a bit closed-minded about the state of the world, and it's important to get out and experience different cultures, I think, to get a better understanding of how people come at a particular problem or social issue or public debate. So I love going to different places and understanding people's backgrounds from those places. So I've got this hunger in me to do that, to find new parts of the world where things can be done so differently. It's really refreshing. It's exciting. Sometimes it's not what you'd want, but also it does show you how social problems at home might seem intractable, but are in fact solved quite differently in other parts of the world. So I love that kind of travel, and working in these different places was obviously a really unique experience where you get to tackle problems differently, have a different role as a lawyer, as a practitioner, and they were great opportunities and I really enjoyed them.
We've got a lot of ground to cover, so we'll get back to Melbourne in the year 2010. You're back here. You're in your late 20s, I'm guessing, at that time?
Sounds about right.
Did you intend to stay at Blackburn's, or were you open to anything that came along?
Yeah, I was definitely interested in looking at different opportunities, but it sort of didn't surprise me that, again, Bernard Murphy gets on the phone and says, I want to set up this practice at Maurice Blackburn that does public interest litigation. You should come back and do that. And that, again, was a fantastic opportunity. I mean, I think I've often been in the right spot at the right time, but I think also the firm is a place where those kinds of opportunities crop up. So it was a great opportunity, and I did come back and then set up that practice. So they were interested in setting up a dedicated public interest practice, in part because some of this litigation is very large and needs to be resourced appropriately. It's not something that you can necessarily do in your spare time as a fee-earning practitioner. So there's some expertise and organisational resources that need to go into that. And I think that was a shrewd move on the part of the firm, because it is important, if you're committed to doing pro bono litigation or public interest litigation, that it's well resourced. And so it was a real privilege. I got to set up this practice and look at different kinds of cases that I could bring that would otherwise not be financially viable, or that did not necessarily come from cohorts of our clients traditionally, and look at how we could bring interesting public interest litigation that contributed to a better justice system and gave people a chance to have their case heard if that's what they wanted. And so that's the work I did in that department.
So a public interest litigation department is purely pro bono. There's no
correct, yeah,
financial return to the firm.
Yep. So
how does it sit in the firm? I mean, how did you get the resources? I mean, a firm like Blackburn's hasn't got a whole lot of people sitting around doing nothing, and therefore you can grab them to get involved in non-fee earning work. How did you resource it?
That's right. So we had a mix. We employed people specifically to do that. Sometimes if there were people who were at a loose end for whatever reason, they could work on it if that worked. But I think quite importantly, there were people dedicated to doing the work specifically. And it got a budget like any other department. It was a commitment that the firm made at the top level to do this kind of work, to do it well. And to make sure it was resourced appropriately. We'd often work in partnership with community organisations or legal centres as well to deliver on that work. So there's a lot of flexibility there, but I think it is important to properly resource pro bono work. And I think a lot of firms do that very well, but it can be, just from a practical perspective, a difficult path if you don't have the proper commitment at the top level to resource it to the degree it needs it.
And so what sort of matters did your public interest litigation department do?
I had an amazing time doing that work because it was extremely enjoyable. It was very stressful and hard because I felt a huge obligation to the clients we worked with, usually because they're not people who would go to court normally, and they felt very invested in this kind of litigation. So I remember it now very fondly, but I also found it very stressful just because of that heavy burden. Probably my favourite case from the time was I did represent an Aboriginal community just north of Tennant Creek who were owners under legislation in the NT, owners of that land. And
can I just stop you there?
Yeah.
How did people who live north of Tennant Creek in the Territory come to Maurice Blackburn's in Melbourne to help them?
That's a fair question. So we'd work with community activists and environmental defenders officers, environmental lawyers who would spend time in those communities doing this kind of work, and they identified a dispute, which is the local Aboriginal community didn't want a nuclear waste dump being built on their land. The relevant land council had nominated it to the Commonwealth as a potential site, and there was a dispute about whether that was a valid nomination, whether that was exactly what the community wanted. And lawyers who do this kind of work on the ground in places like the Northern Territory on behalf of environmental legal centres or on behalf of other kinds of civil society organisations, they identified this dispute and brought it to us. And probably did that because they thought we'd take it on, and they were right. And we worked with some other lawyers as well who worked it up as well, so it wasn't just Maurice Blackburn. But it was very gratifying. These are people who have a lot of suspicion of the Western legal system, often feel like they're ignored and have to stand up to significant sources of power. And in this case, put that all on the table. So it was the Northern Land Council, it was the Commonwealth who were trying to pursue this project. It was a group of Aboriginal people who have been, traditionally extremely disenfranchised and faced incredible difficulties and challenges in their home communities, saying no to this. And I have very fond memories of that whole experience now because we were ultimately successful, but I felt very stressed and worried about not being able to deliver on the promise of bringing that litigation. And we asked a lot of those clients. I mean, I think it's a credit to my supervisor at the time. I would travel up there a lot to talk to them and gain trust, but it was always a very difficult argument to make that you could have faith in this system, that it would listen to you and it would deliver the right outcome. And it's fortunate, I think, that we did get to that point, which was great. So that finished in 2016 and there's no nuclear waste dump on that land. And I'm still in touch with many people from that community who still call me nearly 10 years later and talk about various matters that they've got going on or issues they want to litigate. And I very much value those relationships.
Did it finish in litigation or did it finish in a settlement?
We were halfway through trial and the Commonwealth and the Northern Lands Council withdrew. So decent way in and significant resources expended at that point, but a good outcome.
And what about the East Melbourne Fertility Control Clinic? It used to get a lot of publicity with a lot of angry demonstrations outside the clinic.
Yep.
You were working on behalf of them as well.
Yeah, this is probably my other favourite case, working with the staff of the fertility control clinic. So people may remember in 2001, a security guard out the front of that clinic was murdered by an anti-abortion fanatic. So this is a very difficult place to work. In my opinion, delivering vital healthcare services, including terminations, but all sorts of other procedures as well. And every day the staff would experience harassment going to work. Obviously, we're extremely frightened of the experience and it's to their credit they continue to deliver that service for women. Fast forward a number of years later, abortion has been decriminalised, but the harassment continued. And the staff at the clinic were really committed to the idea they needed a bubble zone around the clinic to protect them, where people couldn't come and harass them and that police were empowered to do something about that harassment when it occurred. We acted for them and brought a complaint against the Melbourne City Council under the little-known health and wellbeing legislation, which ended up being the foundation for a lot of measures to protect people against COVID. So it became very important later on. But at the time, it was about remedying nuisances that occur in the local government area. We argued that the council had an obligation to do something about the harassment. And we were ultimately unsuccessful. So it was I definitely was a big loser on that case. But the very important thing about that was it created the terrain for law reform. So what the clinic was then able to do was to go to elected members of parliament and say, we've tried everything to fix this problem. What we really need is legislative reform to create a bubble zone. This is your job now. And the fact of the failure of the Supreme Court action was the foundation for that claim. And to their credit, MPs responded and introduced a protection zone around the clinic shortly thereafter.
They enacted a specific act for that bubble zone.
Correct. So protection zones around health services that provide abortions. And again, I felt this grave concern that maybe this litigation wouldn't deliver on the promise. And I'm still in contact regularly with the person who gave me instructions, who was the psychologist at the clinic for over 30 years. But she reminds me, and we've written a book about this together, that, the day that was introduced, it stopped and they haven't had harassment since. And that makes me feel really good because sometimes you can sort of hope that might be an outcome of litigation and a journey towards legislative reform, but you're never really convinced it might happen. And in this instance, it did work. So that's great.
You mentioned a book there. Lizzie, I'm almost getting exhausted listening to your life, and it gets even more hectic from now on. 2015 to 2017, you're doing a master's at Columbia University in New York.
Yep. You
write a book and you work in the UK. It's a pretty frenetic pace to live your life at. What took you to New York, firstly, to do a master's? And what area did you do your master's in?
I did my master's in human rights. I was very fortunate. I received a scholarship or a fellowship to go and attend with reduced fees focusing on human rights and corporate accountability, which is what I'd spent a bit of time in my practice life doing already, but it was something I wanted to do in my master's. It's obviously a very interesting institution. You get all sorts of interesting people coming and talking. I think the first week I was there, Kevin Rudd gave an address. So, you know, these are the kinds of people who wander through Columbia Law School on the regular, and it's obviously a privileged position to be in to be able to attend there. It also gave me the freedom to explore some of the ideas that I was interested in, and one of them was around, that had been simmering in the background, around digital technology and the protection of people's human rights in online spaces. And so the freedom of studying away from practice gave me the chance to distill that and turn it into my first nonfiction book, which really focuses on history and technology and politics. It talks about how lots of the novel debates, or seemingly novel debates about technology that we have today, are actually very historically grounded. There's lots of instances in history where we've debated the same kinds of topics. How can we learn from that and make sure human rights are protected in the 21st century, particularly as digital technology takes up more and more of our lives? And to make really technology about humans and about democracy rather than just making a small number of people very, very wealthy. And so that was my motivating force behind getting a book out into the world, but thinking about these topics, working out how law can be useful in that context, and being part of movements to protect human rights in very practical ways.
As someone who is a member of our society, obviously, and watches, maybe from afar, what is happening in the digital world and how the proprietors of the digital businesses make uncountable billions and seem to get away with virtually little, if any, regulatory control, do you think you're winning the battle?
I think it's been astonishing to watch this unfold since I started writing this book. So people may not remember, but when I
should say, Lizzie, what is the name of the book?
Oh, sorry. The book is called Future Histories, and I started writing it in 2015. I suppose it came out a bit later than that, but it was right at the crest of the positive feelings towards the tech industry as being a new and novel way to reshape the world as a force for good. And then things like Donald Trump got elected, Brexit occurred, and people started to question actually whether there was too much dominance of a small number of companies in how we have public debates online. And we got this techlash where people started to resist the idea that tech companies were inherently good. And it's hard to remember, but, you know, Mark Zuckerberg at one point was mooted as a presidential candidate, and it's almost impossible to imagine him getting anywhere like that today. And I think people's attitudes to technology have changed. In fact, there's a huge appetite for regulation. Regulators all over the world now talk about the need to regulate big tech, and they're doing it in places like Europe, even in places like the US and here in Australia. How you solve the problems that have been created is the tricky question. So there's an appetite for regulatory reform, and I see that. I'm the chair now of a digital rights organisation that I set up in 2016 with a number of other people. We're called on all the time to talk about policy issues that relate to digital technology.
What's that organisation, Lizzie?
It's called Digital Rights Watch, and we do a lot of work talking to MPs, putting out campaigning materials, talking to the public as well about what they can do to reclaim their rights in online environments, but also highlight some of the problems that are lingering, that are occurring under the surface that might not be fully identified yet, so that we can get on top of this. Law is notoriously slow at coming to terms with these social problems, but I think there is an appetite for reform. It's figuring out how to put human rights at the centre of that. There's a role, I think, for technology to play in boosting the economy and bringing about productivity, but I absolutely am convinced that the best kinds of technology will have human rights at their centre, that will be about empowerment and not just profit or surveillance and control. And so that's a critical discussion that you have to have at the outset as soon as possible, rather than something you tack on at the end.
With all of the conversation going on at the moment about artificial intelligence, are we having the right conversations now about the regulation of artificial intelligence?
I personally think the government could do more to engage with civil society. I would say that. I'm a member of civil society. But what I would note is that a lot of the material that's coming out from our federal government about artificial intelligence, I think it's generally in the right direction. But there's a big emphasis on talking to industry, on talking to academic experts, and treating it as a technocratic issue, which I understand there's a place for. But I also think there's a role for civil society organisations that have stakeholders that are people, that have a movement of interested citizens who are concerned about how they will be treated by both tech companies and lawmakers, and want to have their voice heard in the mix, that have a different set of stakeholders. And I think the government could do more to improve the ways in which civil society are engaged with and spoken to, and those kinds of discussions take place. So I don't think it's just a technocratic matter. I don't think it's just a matter for an industry to work out. I think it is an issue that needs to have citizen input. Artificial intelligence at the end of the day is sophisticated machine technology, but it's applied to data, often about people. And what we know about that data, or how it's generated, how it's taken from people, sometimes without their consent or knowledge, how then it's used, perhaps in ways that weren't intended. These are all questions that I think have to engage with the people who are at the centre of it. And until we focus in that way, I think we're constantly going to get problems with the technology that comes down the track. These are not easy problems. There's lots of, particularly academic organisations, that are engaging with governance in the AI space, which I think is positive. But I think there's a really important role for civil society to play in those discussions.
It would seem to me, as a member of that civil society, and I guess an older member, it can be overwhelming, and therefore my generation, which is probably not the relevant generation, but even younger generations, I suspect, may feel overwhelmed and therefore turn away from the issue rather than become engaged in the issue. Or am I just out of date?
No, I think that's a very common phenomenon. It feels as though these are very powerful institutions as well, extremely profitable companies that are larger than many nation states, for example, that are very dominating, that almost feel too large to properly be brought under the rule of law. So I think that is part of how the discussion is had in the media. And so part of my role also is to debunk that and say there's things that we can do, there's demands that we can make on lawmakers, there's creative policy making occurring in other parts of the world. Here's what we can look to for inspiration. So there is a set of concrete steps, I think, that can be taken. But I completely understand why people may feel overwhelmed when you read about this in the press alone. What I would say is that's partly why we exist, to give people a vehicle for talking about the steps we want regulators to take in our name, the ways in which we think these companies can and should be held accountable, and that I think people as well have some of the most important stories to tell because they're on the front line of this. They see their kids go to school and get exposed to all sorts of educational technology that they don't like and can't do much about. They see their kids online in online spaces, or they themselves exist in online spaces that aren't very fun, that are unpleasant, that feel predatory, that are addictive, that expose them to harmful industries. And more generally, they see the way in which protests and other people who are interested in expressing dissent might be cracked down upon by a large surveillance state. So that they're experiencing those problems. They know what they're like firsthand. And I think there's an important role for them to play in speaking about them.
Has this spilled over into your professional life? Has there been litigation come out of these issues?
Yeah, well, I certainly do work at Maurice Blackburn that relates to this or makes use of that expertise. So I have been involved in multiple privacy complaints. I'm sure many listeners may have had their data exposed in recent large-scale privacy interferences. So, things like Medibank and Optus that occurred a little while back. I'm managing our complaints to the relevant regulator on behalf of many of those people who may have experienced harm because their data was lost.
Are there likely to be class actions coming out of those?
There are currently as well. It's a space where I think privacy law needs to be reformed. That's one of my big objectives this year with the current Attorney General to engage in privacy reform, in part because it's not entirely clear what the best method is for achieving redress for people who have experienced privacy harms through data breaches. And I think the law could be improved in that respect. So I do that work. I mean, some of my class actions have involved very big name tech companies. And so that, of course, does lead me to use some of the analysis that I gather in working on policy issues and reading expansively about digital technology. So it's certainly useful, and there's an overlap between the two. And that's partly also why it's interesting to work in this field, because I get to do policy advocacy work, and then I also get to think about how you could turn that into litigation. And I think it is a cutting-edge field of law because there's a huge amount of bad behaviour that goes on among large Silicon Valley companies as well as others. There's a lot of possibility in the common law as well as statutory law to find ways to redress that harm, to create avenues for people to seek compensation. And it's about putting those things together. It's a very kind of creative and entrepreneurial field of law in a good way.
Lives in the Law is proudly sponsored by City Maps Illustrated. Their recent publication, The Melbourne Map, is a celebration of our wonderful city. This stunning, hand-drawn illustration, which took more than 3 years to create, is available as an art print, jigsaw puzzle and calendar. The perfect acquisition for your home, office or corporate gifting.
Lizzie, from a professional point of view, you are relatively young and in a relatively early stage of your career. Do you have any vague roadmap for what the future may hold for you? Or do you just deal with things as they come up, see where the cards fall and then just make a decision?
Well, an interesting question, because I know everyone expects that people think about this, but I'm not sure I do, and it's interesting to be asked about it in this context. I like that you think I'm still a relatively young lawyer. I'll put that down to my skincare regime. But I suppose what I'd say is my approach in life is to do things that I think are ethical, that contribute to the society in a positive way, to do work that I enjoy, and hopefully those parts of the Venn diagram intersect, and so far they have. So I sort of have started as I intend to continue. I don't have some long game or particular ambition. I more want to make sure that I stay true to what I promised to myself early on, which is I'm going to spend my life trying to do the right thing by people who otherwise don't get a voice in society, that are otherwise too easily ignored, to use the great privilege of an excellent education, of the admission to a very important profession, to put that to the service of people who would otherwise not be listened to. And so that's the abiding commitment that I've made to myself. And I don't want to look back on my life and think, oh, that's where I lost my way because I was more interested in something else. And I think that's the abiding value that I have. And I think a lot about, I mean, maybe this is morbid, but I think a lot about dying, and I'm worried that I don't want to be regretful of how I've spent my time on earth. That doesn't mean that it's necessarily easy or fun or the path of least resistance, but it means that you don't regret wasting the immense opportunities that have been made available to you, to someone like me, that I've put that to the service of others, and that's the primary obligation I feel. So in that sense, that's how I intend to continue my career, without any particular destination in mind, but certainly with a process that I hope will lead overall to a sum that's bigger than its parts.
A theme which has come out through our conversation, maybe not as overtly as in other conversations, but it's still there, has been that you've benefited from excellent mentorship. Particularly, you mentioned Bernard Murphy a couple of times, and that comes out in all of our conversations. People who have achieved things, people who have done things, there's this enormous benefit that accrues to them because of other people investing in them. Where's your role in that? Now that you're a principal at a firm, what do you say to young lawyers who are coming along? Do you feel an obligation to help them in their journey?
100%. So I wouldn't be anywhere near where I am now if I didn't have the benefit of people who saw something in me and gave me the opportunity to explore my potential, including making mistakes, including probably being a pain for them at various points in their careers as well. And, you know, Bernard Murphy's one of them. I'd also put Andrew Watson, who was my subsequent head of our Department of Class Actions, is now a judge. These are people who really wanted me to succeed and saw something in me that they thought was worthwhile and gave me a go. So I think it's absolutely the obligation of anyone who's experienced that, and almost anyone in the profession could point to instances of that in their career where that's occurred, to pay that forward. And I'm always happy to talk to anyone in the early stages of their career, or students who are interested in going into law, to talk about ways that I can help them find out what they want to do, or get them in front of opportunities that might be good for them. I think it's your duty to do that. And to be honest with you, I think the profession generally understands that. In my experience, almost any lawyer that you speak to would be prepared to do that, and I think that's to their credit, because they all understand that these things are not just part of your innate goodness or excellence, that they actually are communal activity. Learning to be a lawyer, gaining opportunities, these are all things that often come from other people, and that it's important to pay that forward to others. So I genuinely mean that offer that I made, that if people are interested in working out what they want to do or what a career looks like in the field that I'm in, I'm always happy to talk to them about how they can improve their chances of taking a similar path, but also where they may wish to deviate, how I can put them in touch with people who may be able to help them as well. And in general, my experience is that everyone's willing to help.
Lizzie O'Shea, thank you very much for coming in this morning and being a part of our Lives in the Law series. Your life has been so far interesting and extremely worthwhile, I think, in the contribution you have made and are making, and all the very best for the foreseeable future, maybe another 20 or 30 years of making a contribution.
Thanks so much for having me.
Show notes from today's episode can be found at greenslist.com.au/podcast. There you'll find links to things we've talked about in this episode, a transcript of the show, and some wonderful photos of our guests. If you're enjoying Lives in the Law, please tell your networks, subscribe, rate and review the show. Your host is former lawyer and Greens List clerk Michael Green. Our show is produced and edited by me, Catherine Green, mixed and mastered by Windmill Audio, and recorded by Alex McFarlane, who also wrote and performed all the music for the series. We're coming to you from the iconic Owen Dixon Chambers on the corner of William and Lonsdale Streets in our beautiful city of Melbourne. We acknowledge the Wurundjeri people of the Kulin Nation as the traditional custodians of this land and pay our respect to their elders past and present. There is no doubt that conversations about justice have been taking place on this land for thousands of years, and we are privileged to continue that discussion here today.